Hi everyone, Dave Sugden of Evidence at Trial. We are talking about the recent Colorado Supreme Court ruling wherein the court held that former President Donald Trump cannot appear on the ballot because, under Section 3 of the 14th Amendment, he is disqualified from holding the office of the president. In our last video, we discussed how the Colorado Supreme Court reached this unusual conclusion. And in this video, we're going to look at the evidence the trial court considered, specifically Congress's January 6 report. Donald Trump's team argued that the report was a partisan document and inadmissible hearsay, while the petitioners argued it was admissible under a hearsay exception. So what is actually going on here? The reason there's a general rule against admitting hearsay evidence is because of the concern the evidence is not trustworthy. The way our judicial system gets to the truth of disputed facts is through the tool of cross-examination. People can say all sorts of things they might think or even believe are true, but when such things are subject to the scrutiny of an effective cross-examination, what is actually true can become much clearer. As a result, we have this general rule that hearsay evidence is not admissible. But the hearsay rule has a number of exceptions, and among the reasons several of the exceptions exist is because the hearsay or out-of-court statement is, for various reasons, deemed trustworthy enough. And that takes us to the January 6 report in Donald Trump's trial. The Trump team argued that it was essentially a partisan political document, while the petitioners argued that it was an admissible public record. There is a public records exception to the hearsay rule, and it is found in Colorado's Rule of Evidence 803, Subdivision 8. This exception excludes from the hearsay rule reports of public offices or agencies in civil actions that include factual findings resulting from an investigation made pursuant to authority granted by law. So, a congressional report like the January 6 report seems to fall squarely within this exception, but the rule begins by saying this exception only applies unless the sources of information or other circumstances indicate a lack of trustworthiness. And that lack of trustworthiness element is what Donald Trump's team relied on to argue that the January 6 report should not be admitted. So what do we think? Were there circumstances that indicate a lack of trustworthiness of the January 6 report? The Trump team focused on the folks who served on the committee who authored the report. According to House Resolution 503, introduced by Nancy Pelosi in June 2021, then Speaker Pelosi was to appoint 13 members to the committee, 5 of which shall be appointed after consultation with the minority leader. Then House Minority Leader Kevin McCarthy recommended 5 Republican members to serve on the committee. However, Pelosi passed on 2 of the 5 recommendations, Jim Jordan of Ohio and Jim Banks of Indiana. Pelosi explained her decision, and it wasn't because she hates the name Jim. Instead, she explained that with respect for the integrity of the investigation, with an insistence on the truth and with concern about statements made and actions taken by these members, I must reject the recommendations of Representatives Banks and Jordan to the Select Committee. Pelosi then said, the unprecedented nature of January 6 demands this unprecedented decision. McCarthy responded to Pelosi's vetoes by basically taking his ball and going home. McCarthy said that he would not appoint any replacements and that the GOP would not participate in the Select Committee at all. So instead of 13 members, the Select Committee was composed of 9 members, 7 Democrats and 2 Republicans, Liz Cheney of Wyoming and Adam Kinzinger of Illinois. Trump's team argued that the entire makeup of the Select Committee made the report a partisan document and untrustworthy. Beyond the party imbalance of the committee, the 2 Republicans, they argued, were both biased against the former president. During the trial, Timothy Hearsay, who served as the chief investigative counsel for the committee, was asked about various statements made by the members of the Select Committee before the investigation began and how they had been pretty vocal about their disdain for former President Trump and how they believed Donald Trump was responsible for the events of January 6. Mr. Hearsay acknowledged that these members had made various statements, but testified that they had merely formed a hypothesis as to what had led to the events of January 6. The Denver District Court adopted Hearsay's characterization and held that although the committee had developed this hypothesis, they remained open to whatever conclusions were supported by the evidence uncovered in the investigation. Now, that's a nice idea, but really, was it merely a hypothesis? all members of the committee had already voted to impeach Donald Trump for his role on January 6th. Liz Cheney said at the time that Trump summoned this mob, assembled this mob, and lit the flame of this attack. She called what Donald Trump did the greatest betrayal of a U.S. president ever. Adam Kinzinger said at the time he voted for impeachment that Donald Trump incited this insurrection, and if these actions, the Article 2 branch inciting a deadly insurrection against the Article 1 branch, are not worthy of impeachment, then what is an impeachable offense? And these were the two Republicans on the committee. The Democratic members were even less charitable in their comments. So was it merely a hypothesis that was investigated with open minds? Let's suppose, for example, a committee was formed to investigate whether or not the 1996 Chicago Bulls were the best NBA team of all time. What would we think of the investigation if we knew all committee members grew up in Chicago and had, before the investigation, formed a hypothesis that no team had or would ever come close to that Bulls team? But the committee says, wait, we're not all from Chicago. 2 members of this committee grew up in Los Angeles, home of the Lakers. Fair enough, but there's still a 7-2 imbalance. And what would we think if the 2 LA residents both hated the Lakers? Would we consider their conclusions trustworthy? None of this mattered to the Denver District Court because it wrote all congressional investigations have some political bias or motivation underlying them, and courts have admitted congressional reports for decades. Fair enough, but that's not the rule. Congressional reports are not per se admissible. The rule still requires the court to examine whether the circumstances behind the report suggest that it's untrustworthy. Acknowledging this rule, the court then essentially held that any concern of untrustworthiness is the fault of the Republicans because they decided to not meaningfully participate in the investigation. The court wrote that while the court agrees with the interveners that the January 6th report would have further reliability had there been greater Republican participation, the events pointed to by petitioners demonstrate that the Republicans had a meaningful opportunity to participate but simply chose not to do so. But that rationale entirely misses the point. The rule does not ask why a report might be untrustworthy, it asks whether it is untrustworthy. To tackle this issue, the court chronicled the committee's diligence, wherein they deposed more than 1,000 witnesses, collected and reviewed more than 1 million documents, reviewed hundreds of hours of video footage, and reviewed various federal and state court rulings related to the 2020 election. Again, fair enough. But the argument was not about the committee's diligence, it was about their bias. Going back to our Chicago Bulls committee, would we still trust their conclusions if they insisted that they, as part of their work, watched a bunch of game film from the Lakers and Celtics from the 1980s, even hundreds of hours of game film? We'd certainly acknowledge their effort, but concerns would remain whether their supposed hypothesis was something closer to subjective bias. Again, it will be interesting to see what the U.S. Supreme Court does when it takes up this issue and whether it will take up this hearsay question. Folks, I hope this was helpful. If it was, please like, subscribe, hit the notification button. If you want a topic covered, leave a comment. If you want to do a deep dive on these evidentiary issues, check out our online course page at evidenceattrial.com. Thanks for watching.